Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we typically talk about challenges to ridiculous gun laws all around the country. And of course, typically the challenge is based purely on a full frontal attack, which is through the Second Amendment. How does that work out for us often? Okay, and even though it is stated time and time again that the Second Amendment is not a disfavored right, it sure appears that that is in fact the case. And so sometimes we have to perhaps get a little bit more creative in how we're going to attack some of these ridiculous gun laws. I'm going to share with you a case out of Pennsylvania today that I think it does exactly that. And when you see the little chess game that's been played here, it's a really good move and it's got potential to challenge other gun laws in the future. I'll explain it all in a few moments. So today, let's spend a few minutes and let's talk about a new constitutional challenge to terrible gun laws. Okay, America, we are talking about this crazy little statutory scheme where in the state of Pennsylvania, it is unlawful for you to conceal carry a firearm anywhere in the state unless you have a concealed carry license. However, it is unlawful to open carry a firearm unless you have a license inside only the city of Philadelphia. And obviously the case here in Commonwealth of Pennsylvania v. Sumpter, the case we're talking about today, was of course arrested in Philadelphia. Now, what he challenged this is not that this law was violating his Second Amendment rights. We're not even going to get into that today. Instead, no, he challenged it under equal protection grounds. Where does equal protection come from? It comes from the 14th Amendment, which, as you recall, states, "No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." More easily put, the law cannot have differential application to those who are similarly situated, i.e. the difference between carrying a firearm outside the city of Philadelphia versus inside the city of Philadelphia. And listen, this worked because the court points out, for purposes of appellant's equal protection argument, which we conclude is dispositive, we analyze the constitutionality of Section 6108 insofar as it prohibits the unlicensed open carry of firearms on public streets and public property in the city of Philadelphia. Now, here's the big thing why this could be really successful. Unlike a straight 2A challenge where we are actually challenging the constitutionality of the statute, under equal protection, you're not necessarily challenging the actual constitutionality of the statute's existence. What you are challenging is whether or not the law is being applied to you in an equal fashion. And the court kind of structured the differences this way. Heller, McDonald, and Bruin examined whether there was a historical and textual precedent to support the modern-day regulations at issue in those cases. In other words, the validity of the regulation is what was at issue. Equal protection analysis continues to use tiers of scrutiny, strict, intermediate, and rational basis, depending on the classification involved to determine whether a law unfairly discriminates against a particular group of similarly situated persons. Under an equal protection analysis, the validity of the underlying regulation is not per se at issue. The issue is whether the law, regardless of its validity, unfairly discriminates against similarly situated persons subject to the law. Which means we don't get into history or that very, for whatever reason, gray area that you see courts get very, very creative that want to support civilian disarmament legislation, as the court here put it. The Commonwealth's attempt to use history to bolster its equal protection argument fails because an examination of history largely misses the focus of an equal protection analysis. Here, when addressing equal protection, we're not so much concerned with the validity of Section 6108 as we are with whether appellant is unfairly discriminated against under that law in comparison to persons outside Philadelphia. Okay, now you heard those terms, tiers of scrutiny. You're like, well, that's exactly how they screw us. That actually is how this is going to work, okay? Let me explain how the court put it so you can understand how these tiers of scrutiny work. When faced with an equal protection claim, we normally apply one of three levels of scrutiny. Strict scrutiny to the restriction of a fundamental right. Intermediate scrutiny to the restriction of an important but not fundamental right. And rational basis review in all other instances. Okay, this law was previously challenged a number of years ago under equal protection grounds, okay? But the court at that time, for whatever reason, had found that, well, it withstood a rational basis scrutiny. And you sit there and you go, wait a second, rational basis, that's for all other instances. We're talking about a fundamental right. Yes, that's exactly what we're talking about. And that's where the court went with this. Because what they basically said is hey, listen, if you take a look at Heller and Bruin and Rahimi, it is very clear that the right to keep and bear arms both inside and outside the home is an absolute fundamental right, which means that any law that we're going to see challenged under equal protection must survive a strict scrutiny analysis moving forward. And that's what actually cooks the Commonwealth of Pennsylvania here, because now with a strict scrutiny analysis, the court rules, as explained above, the Equal Protection Clause requires that all similarly situated persons are treated alike in the exercise of constitutionally protected rights. And when presented with an equal protection claim regarding a law that burdens a fundamental right, the law is subject to strict scrutiny. Under strict scrutiny, the Commonwealth must establish that Section 6108 is narrowly tailored to achieve a compelling government interest. And then, of course, the Commonwealth pleads, well, we got to stop crime, which apparently is only unique to Philadelphia. Now, I'm certain that Philadelphia has a crime issue, but I'm sure it is not unique to the city of Philadelphia. I don't think the court was too impressed upon that either. And so ultimately, where the court gets, because of this strict scrutiny analysis now under this equal protection challenge, these precedents foreclose any argument that the Commonwealth's stated interest, providing law enforcement with additional tools to combat crime, is sufficiently compelling to support an impingement of the fundamental right to keep and bear arms in the city of Philadelphia. Okay, now I want you to think about this for a second. It would have been real easy to file a challenge against the city of Philadelphia or against the Commonwealth of Pennsylvania saying you're violating my Second Amendment rights while I'm inside the city of Philadelphia. And you can imagine how those courts may have dealt with that issue. Instead, hey, as a resident of Pennsylvania, I am treated differently by the same law once I get inside city limits versus when I'm outside city limits. That's a violation of equal protection. Then, and I will also point out that this was the issue in United States versus Scrutiny. That, of course, is the case involving trans medical issues and rights coming out of the state of Tennessee that the United States Supreme Court just recently decided. And what was being argued there, too, is what level of scrutiny must the law, in fact, be held to if you're challenging under equal protection? And had the United States Supreme Court said that those who identify as trans or whatever you want to call that were subject to strict scrutiny, it would have upended equal protection forever. And that was one of the big, huge benefits of what the United States Supreme Court did in Scrutiny, is they actually preserved equal protection moving forward. So again, maybe we're just too frequently going right away to the Second Amendment as the most effective way to challenge it because, well, yes, obviously these rights are being violated. But we have seen time and time and time again now where sometimes it is virtually impossible to get any of these lower courts to take any action. But if we find other constitutional challenges, if we find constitutional challenges in which many liberal justices perhaps have already authored heavily on these issues, maybe that's another way that we can find success. Okay, the case once again is Commonwealth of Pennsylvania v. Sumpter. It comes out of the Superior Court of Pennsylvania. We're going to link it up down below so that you guys can geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the information on that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.